A nationwide judicial system in Iran was first implemented and established by Abdul Hossein Timurtash under Reza Shah, with further changes during the Second Pahlavi era. After the 1979 overthrow of the Pahlavi dynasty by the Islamic Revolution, the system was greatly altered. The legal code is now based on Islamic law or Sharia, although many aspects of civil law have been retained, and it is integrated into a civil law legal system. According to the Constitution of the Islamic Republic, the judiciary in Iran is an independent power. The entire legal system, from the Supreme Court to regional courts, all the way down to local and revolutionary courts, is under the purview of the Ministry of Justice. But in addition to a Minister of Justice and head of the Supreme Court, there is also a separate appointed head of the judiciary. Parliamentary bills pertaining to the Constitution are vetted by the Council of Guardians. History. Islam. According to one scholar, the administration of justice in Islamic Iran has been until recent times a loosely sewn and frequently resewn patchwork of conflicting authority in which the different and sometimes conflicting sources for Islamic law, the jurists, the actual judges, and the non-Islamic law officials of the king, disputed with each other over the scope of their jurisdictions. Some aspects of the law always remained in the hands of the mullahs. The village mullah was the natural arbiter in matters of marriage, divorce, and inheritance, and the exalted jurisconsult, in order to carry out the very function for which he was exalted, gave opinions on those matters of law on which he was consulted. In between the village mullah and the jurisconsult there were mullahs with courts which, while sometimes sanctioned by the royal government, depended for their power on the prestige of the presiding mullah judge as much or more than on the government's sanction. Since the 16th century AD, Iran has been the only country in the world having Shia Islam as its official religion. Consequently, the general principles of its legal system differed somewhat from those of other countries which followed Islamic law. Among the ways law in Iran and the rest of the Muslim world differed from European law was in its lack of a single law code. 13 centuries of Islamic, more particularly Shia, tradition called for jurists to base decisions on their legal training as it applied to the situation being judged. There was also no appeal in traditional Islamic law. One jurist's discovery of the ruling of law for a specific case would not have been invalidated by some other jurist's discovery of a different ruling for that case. Only God could choose between him, and until the resurrection God had left the matter to the jurists, and the first actual judgment was final, as otherwise there would have been an infinite regress of opinions without any final judgment. For the Shia, resistance to a single written code was even stronger. The jurisconsult's right to describe the law in his own way was the very essence of the doctrine that had revived the jurisconsult school at the end of the 18th century. As far as the judicial system is concerned, the changes were quite minor until the end of the 19th century. 20th century major events marking the judicial history of Iran during the modern era include the constitutional revolution of 1906, which gave the country its first constitution and Bill of Rights, the fall of the Qajars and the rise of the Pahlavi dynasty in the 1920s, when accession to a modern judicial organization became one of Iran's greatest challenges, and the Islamic Revolution regime of capitulations, as European military and technological power began to be felt in 19th century Iran. Westerners insisted on special treatment in Iranian courts. This came in the form of treaties between most European governments and Iran requiring the presence at the trial of any European in Iran of a representative of that European's home country. The Europeans insisted on this legal veto right, called the regime of capitulations, on the grounds that Iran had no written legal code so that no one knew what laws foreigners would be judged by. Iran followed traditional Islamic practice of each judge giving his own interpretation of Islamic law for a given litigation, with no right of appeal. Iranians in general opposed these capitulations, and secular Iranians such as Mohammad Mossadegh, wanted to establish a fixed written law they believed would not only end the capitulations but facilitate the building of a strong and unified state. Reza Shah. Under the secularist reign of Reza Shah, many changes were made in Iran's judicial system, and the establishment of a fixed written law with appeals courts was one of them. In March 1926, Minister of Judicial Affairs Ali Akbar Dava dissolved Iran's entire judiciary, with the approval of the parliament, and initiating a wave of fundamental restructuring and overhauling reforms with the aid of French judicial experts. By April 1927, Iran had 600 newly appointed judges in Tehran. Dava subsequently attempted to expand the new system into other cities of Iran through a program involving training of 250 judges. Reza Shah represented his legal reforms as tentative experiments, and allowed the religious judges to keep their courts for matters such as inheritance. In 1936, however, the new system was made permanent and the religious courts were abolished. However, there were still Sharia courts that ruled on issues of family and inheritance up to the Islamic Revolution. Some aspects of Sharia law were also unofficially retained in criminal law. For example, compensation was still unofficially given in a similar manner to blood money, in exchange for pardoning a murder death sentence in some cases. Islamic Republic. In 1979, the secular, westernizing Pahlavi dynasty was overthrown and replaced by an Islamic Republic under the rule of Ayatollah Khomeini. While the revolution did not dismantle the Pahlavi judiciary in its entirety, it replaced secular trained jurists with seminary-educated ones, and codified more features of the Sharia into state laws, especially the law of retribution. Women judges were also removed. Between 1979 and 1982, the entire pre-revolutionary judiciary was purged, and the duties replaced by revolutionary tribunals, set up in every town. These tribunals ruled on Islamic law, but were in practice unfair, biased, and the judges were inexperienced and often incompetent. Many people were executed or given harsh punishments for both political and criminal acts. There were no appeals either, and trials often lasted minutes in an unorthodox court. In 1982, the regular court system was reinstated, but with the judges now trained in Islamic law. The revolutionary courts became a part of this court system, ruling in matters of national security, such as drug trafficking and political and anti-revolutionary crimes, and were considered the judicial arm of the regime. In 1982, in response to military coup threats, a separate military revolutionary court was formed, handling military cases. The Retribution Law of 1982 replaced sections of the Public Punishment Law.